In this lesson, we're going to explore how business activities may lead to legal disputes, and then we'll look at the range of options for resolving those disputes. We are going to look at the litigation process, but I need to emphasize that litigation should be a last resort for resolving most disputes. We're going to look at other options for resolving disputes, and we're going to focus on resolution as quickly and cheaply as possible. Businesses should strive for the most efficient manner of resolving disputes and generally not be preoccupied with winning at any cost. As always, I've provided for what you need to know. So you need to know how business activities can actually lead to legal disputes, the options for resolving a legal dispute, the alternative dispute resolution methods, and then the litigation process itself. As we identified in the last lesson, businesses can't avoid legal risks at all costs. Instead, what we need to do when it comes to legal risks is to manage them. And our goal in managing these legal risks is to avoid time-consuming and costly litigation and preserving long-term commercial relationships. As we've already seen, business activities can lead to disputes. This slide covers a bunch of different ways, so pollution, motor vehicle accidents, hacking attempts, bylaw changes. I'm not going to go through all of them, but I'll talk about a few just so you get a general idea of how business activities can lead to disputes. So the first would be a pollution incident. Let's say that under the normal operations, there is some kind of chemical spill that leads to a major or even a minor incident of pollution. In such case, the organization must report the incident to the relevant environmental agency by law. And as we've discussed previously, this isn't necessarily simple as there are jurisdictional issues when it comes to the environment. The organization also has to report the incident to their insurer. They are contractually obligated to do so. And then finally, a legal dispute may arise if someone else is impacted by the pollution. So perhaps a farmer or a fisher or a resident whose enjoyment of their own property might be impacted by this chemical spill. Now we look at the delinquent customer. So this is a customer who might just refuse to pay their account. In those cases, the organization has to think carefully about how to best resolve this. They could consider, do they sell the account to a debt collector agency? Do they take the customer to court? The organization should consider things like the size of the loan, the circumstances of the customer, and the impact on their reputation. They need to consider lots of factors in order to choose a decision that makes the most sense for the organization. And then finally, I'll talk briefly about the problem employee. How should an organization deal with a problem employee? Reprimanding them or firing them could actually lead to a lawsuit or a human rights complaint if it's not handled appropriately. What about a negotiated settlement in exchange for the resignation of the employee? That might work. Again, the organization has to consider many things. They should consider how long the employees worked for the organization, the employee's prior behavior, the rights of the employee, the reputation of the organization, and so on. There are a lot of things to consider. We're going to talk about some of the options for resolving legal disputes. Figure 4.2 in your textbook, it's at the end of the chapter if you have the 2020 edition. It provides a good overview of the different forms of dispute resolution. It includes litigation, but managing disputes should not automatically mean going to court. Oftentimes, it should be the last resort. This means that businesses need to consider additional ways of resolving their disputes, and that brings us to the topic of alternative dispute resolution. This is a range of options for resolving disputes as an alternative to litigation, and these are also covered in Figure 4.2. The most common methods of ADR are negotiation, mediation, and arbitration. We're going to talk about all three of those. Organizations should be really well versed in alternative dispute resolution because there are a lot of advantages. It preserves confidentiality. It could preserve a relationship, an important relationship with a customer or a supplier. It's often less costly. It's often less time consuming. And alternative dispute resolution leads to an outcome that both sides can live with. Whereas when you go to court with litigation, typically only one side can win. Research indicates that saying sorry can actually go a long way when dealing with legal disputes. However, many organizations have been cautious to say they're sorry because they're afraid of what the apology will mean. They're worried it'll be seen as an admission of liability, and this admission of liability could void an insurance policy, it could encourage the person to pursue a lawsuit, or it could result in a court holding the apologizer liable. It's why a lot of organizations have a policy of not apologizing. However, many jurisdictions in Canada have passed what they call apology legislation, and it covers statements of wrongdoing and of regret or sympathy. For example, in British Columbia, the legislation says that an apology is not an admission of guilt. It's not relevant when a judge makes a determination of liability. It can't be used as evidence to establish liability and cannot be used to void an insurance policy. Despite this, businesses still need to be careful in issuing apologies. One is because this legislation doesn't exist in all provinces and territories. And in some jurisdictions, the facts that are contained in the apology are said to not be part of the apology and are therefore admissible in court. So, as stated in your textbook, you can say you're sorry, but don't say what you're sorry for without risking the making of an admission. That's it for Lesson 4A. I encourage you to go back to the ACORN page and see what's next. Bye for now.